Speaker, the nominee, Dorcas Oduor, all of us in the legal fraternity know that you have previously worked at the State Law Office in the prosecution department. I think mostly people know you as that, as per your CV also. And when the Office of the Director of Public Prosecution was delinked from the Office of the Attorney General in 2010, you transitioned to the Office of the DPP, where you were serving as the second most senior person as Secretary Public Prosecution. Could you share with this committee what you consider was your greatest achievements in the 30 years in your public service? And secondly, if approved as Attorney General, like you rightfully said, you will make history as the first woman Attorney General. Like myself, all the women in the legal fraternity have high expectations of you as one of the most senior women in the legal fraternity. In this regard, tell us what you'd consider to be your vision of the office of the Attorney General should you be approved. Thank you.
Go ahead.
Thank you. I joined the office of the Attorney General in 1992, and I would divide my achievements from the Office of the Attorney General and the Office of the DPP into 4 sectors. When I joined in 1992, for the first 8 years, I was a courtroom lawyer. I prosecuted all manner of cases in all courts to the highest court. The epitome of that was in 2000, when I was nominated to go and assist Kenya in prosecuting the 1998 bomb blast victims, a case in New York. And we successfully did that. Another epitome of my court work was the case that I prosecuted against. It is known as the Gachanja case. The reason why it is my achievement, it is the first time that a prosecutor was able to forfeit instruments of crime and proceeds of crime. In that matter, one of the accused persons had been paid by a piece of land in order to commit murder, and I successfully forfeited what he was paid. That matter went up to the Supreme Court, and it was upheld. My third success in court would be the case of Chris Okemo on extradition. There was a conflict between the Office of the Attorney General and the Office of the DPP as to whose responsibility it is to sign authority to proceed. I did prosecute that case, litigated it, because it was a civil case now. It was a constitutional petition. I did litigate it in the High Court and the Court of Appeal. I filed responses in the Supreme Court. My colleague prosecuted it at the Supreme Court, and we were successful. That matter is now settled, that it is the responsibility of the Director of Public Prosecutions to sign the authority to proceed. That is in the courtroom, among others. While serving in the office of the AG and the DPP, I was able to participate, humbly so. I was appointed by different heads of state in this country to serve in commissions and task forces. I served in the Akiwimi Commission on land clashes, and it is after we had submitted our report that we started land reforms in this country. I served in the Goldenberg Commission, and it is after we submitted our report that we relooked at our PFM Act. I served in the Police Task Force on police reforms, and it is the result of that task force that we now have IPOA, we have the Police Service Commission, we have the IG as a single command of the police and the AP. We also have the merger of the Kenya Police and the APs under single command. Other than task forces within the country, I have contributed internationally in different forums. My first contribution was with the Commonwealth Secretariat. I was called in as an expert to review the Harare scheme on mutual legal assistance. It is after my contribution to the ComSec and successful review of that mutual legal assistance scheme that I came back and proposed to Kenya that we needed a Mutual Legal Assistance Act. The Kenya government agreed, and we came up with an act, and that is the act we are dealing with today, the Mutual Legal Assistance Act. Secondly, I have done a lot of work with the FATF. FATF is Financial Action Task Force. It is a group of G7 and other countries. They set standards on issues of money laundering and asset forfeiture. I am a trained evaluator. I've evaluated 2 countries, one in Africa and one in Europe, on compliance with the 40 recommendations. It is after my contribution to that forum that I came back to Kenya together with my colleagues, and we assisted in legislation of POCAMLA, which is Proceeds of Crime and Anti-Money Laundering. It is also after that that we assisted with the legislation of Terrorism Finance Acts. A product of that is the FIU, the Financial Reporting Unit, the Asset Recovery Agency, and the National Task Force. I've also done some work with the UN. And at the UN, I assisted Kenya when we were negotiating the United Nations Convention Against Transnational Organized Crime. I also took part in the evaluation of that convention. I was again called in as an expert to make a digest, which I provided. And in that digest, I am an expert in piracy. After that, the United Nations accredited me as a trainer in that space. I've also done some work with AGA Africa. AGA Africa is a conglomeration of attorney generals. As the Office of the Director of Public Prosecutions, we collaborated with them, and we have all the black attorney generals in the USA in that forum. They have assisted the Office of the Director of Public Prosecutions in many areas, and they have exposed and assisted the DPP to operationalize the PTI. Other than those, I have done work with GIZ with regard to illicit financial flows. Incidentally, when I heard of my nomination, I was representing Kenya at the UN headquarters to take part in the final negotiation of the amendments of the Budapest Convention on Cybercrime to include issues of electronic evidence and data protection. That was the last call for countries to give their views before the amendments are adopted. And I am hoping that after this initiative, Kenya will accede to the Budapest Convention to bridge the gap we have in electronic evidence and data protection. Allow me, Mr. Speaker, sir, to go back to the Office of the Attorney General and the Office of the DPP. I have served in that office in different capacities. I have acted as the DPP in during 3 transitions, but now I am the Secretary of Public Prosecutions. When we delinked from the Office of the Attorney General, we had only 98 prosecution counsel, and we were in 12 regional offices. It was then my responsibility, together with the DPP, to rationalize staff and to operationalize the Office of the Director of Public Prosecutions. We have managed to increase the staff of the Office of the DPP from 98 to 1,600. We have managed to decentralize the Office of the Director of Public Prosecutions from 12 offices to all the 47 counties, to 131 court stations, and we also serve mobile courts. We have also managed, during that period, to civilize prosecution. What do I mean by this? Initially, police prosecutors were prosecuting in all courts. When we took over, we professionalized prosecution. We no longer have police prosecutors in our courtrooms. This is being done by Prosecution Council. Other than that, when Mr. Haji took over the helm of the Director of Public Prosecutions, he found, when we had an initiative where we were looking at the position or the contribution of the criminal justice sector to the development of this country, and how the Department of Public Prosecutions, or the Office of the Director of Public Prosecution, was assisting or impeding the realization of the objectives of this country. I therefore, together with others, started an initiative called All for Justice. And All for Justice, we wanted to look at the role the prosecution is playing in realizing the objectives of the criminal justice sector. We visited almost all the prisons in Kenya. We interviewed about 20,000 prisoners. And Honorable Speaker and members, I really wonder what led us to do this, because looking back, I realized that somebody was directing my steps. Because the conclusion of that report, which I have here today, indicated that what the prosecution wanted to do could not be done by the prosecution, but could only be done by the Attorney General. And I want to run over 4 of them. When we went through the 20,000 inmates, pretrial inmates, and we checked all the prisons in Kenya, it was a wonder that although under the Constitution we talk about innocent unless proven guilty, it was clear that our criminal justice system is inconsistent with the right of innocence until proven guilty. Why do I say that? We found that most of the people who were in custody for petty offenses. There was nothing we could do because the law provided for them. Then we realized that there is a need for us to relook at our offenses in Kenya so that we can decriminalize petty offenses. At the same time, there is a need for us to find a different way of dealing with petty offenses. So we made that recommendation to the Office of the Attorney General. We also found that most of the people who were in custody were young people and they were poor. There was no mechanism that these people could be assisted. Each time they went to court, they needed bail, and bail is in cash. So we asked ourselves, is cash the only way that we can secure the attendance of accused persons to court? We made the recommendation to the NCAJ, and we're waiting for the Attorney General to attend to it. Thirdly, we also found that most of the people who were in custody were not represented. There was no equality of arms. They could not defend themselves. We made a recommendation to the Attorney General that there was a need to operationalize the legal aid services. Because when people are not represented, they are not able to move through the system. And honorable members and Mr. Speaker, sir, I would invite you people to visit our pretrial detentions. We talk about rights. We talk about the rights of the arrested, the rights of the accused persons, the rights of the detained person, but we have not made it tangible. Because if you visit these institutions, you will wonder what we are as Kenya. None of the people charged with corruption cases was in pretrial detention. It is only the poor. They have no food, they have no classes, cases take very long, and most people who should be in custody are working outside. And most people who should be outside are in custody. There is a need for us to reform the criminal justice sector. We also observed that cases were taking very long, and there was a need for us to expedite those cases through the system. As a result of that, DPP Haji, myself and the office tried to come up with initiatives within our power. And that is why we came up with the decision to charge guidelines. And that is one of my biggest achievements, our biggest achievement. The decision to charge guidelines is supposed to regulate how we make the decision to charge, so that we sieve the system, petty cases do not go to court. We also came up with the diversion guidelines, and the diversion guidelines is supposed to attend to alternatives to prosecutions, because we realize that not everybody who is charged with an offense should go through the system. And that was said by Sir Shawcross, the Attorney General of England in 1950. that not in all cases where you have evidence, people should go through court. So we came up with a diversion guideline to assist us to sieve the cases. What is the challenge that the DPP could not deal with that the Attorney General should deal with? A prosecutor could decide to divert, but where are the structures to divert to? Because if I have young people who have been brought to me and I realize that they can be rehabilitated, I need a rehabilitation center. I need counseling services. How many of our counties have rehabilitation centers and have counseling facilities? Therefore, our action is in futility. Prosecutors are being accused of taking many cases to court. It is because we have initiatives, but we need other structures of government to assist us to realize those initiatives.
Could wind up on that?
Yes. And we also found that most of our prosecutors had no capacity, and therefore maybe were making wrong decisions. And that is the reason why, in order to harness and structure the training of prosecutors, we came up with the Prosecution Training Institute. At the Prosecution Training Institute, we now have a fully fledged course where prosecutors can undertake contiguous legal training, specialized training, and also training on emerging crimes. We hope that the Prosecution Training Institute will be a center for the region and will bring A&A to this country. On access to justice, we found that prosecutors were having a difficulty in attending court. We therefore digitized. We have Wadilifu. Most processes within the office of the DPP are digitized. In order to enhance access to justice, we, together with the EU, got a boat to help us to attend to courts that are outside the normal courts, that is in Lamu. And it is also pursuant to that initiative that we came up with community initiatives where we would go to the community and have community dialogues so that we can tell them about their rights and the criminal justice sector. And it is also pursuant to that we did another research on traffic to find why it is impacting the criminal justice sector. We find that it is clogging the criminal justice sector. Most of the crimes that we arrest people for are non-moving and they are petty, like not wearing a uniform and touting. And it is for that reason that the Director of Public Prosecutions directed that touting should not be charged so that we don't clog the system. I have put all that before you.
Yes.
And at an appropriate time, if I'm nominated, I intend to use...
You've been nominated if you are found suitable.
If I am found suitable, Honorable Speaker, sir, and members,
yes,
this experience will help me to oversee and to steer the Office of the Attorney General. Thank you.
Ichungwa, Majority Leader.
Thank you, Honorable Speaker.